Welcome to a session reviewing the topic of transfer of title. For those who've already gone to try and pass that real estate exam, transfer of title is found on the national part of the exam. Yes, it doesn't have that many questions, but for some, this is one of those difficult topics because it's not stuff that you hear on a regular basis. At the end of this video, we shall review how many questions you get on the PSI exam. My name is Brenda Kasuva. Thank you for being here. Subscribe, share with others about our channel past that Maryland real estate exam. We start with this first question. At any time, if you're watching this, you can always pause and see whether you're able to come up with the answer. After a couple of moments, I will go ahead and share the answer and why. For that person who's listening, we're going to go ahead and read it out loud. Which document is essential for transferring ownership of real estate? A. Title insurance policy. B. Mortgage agreement. C. Property appraisal. D. Deed. Here you're being asked, what is that document that is going to transfer the property from the owner seller to the new owner in the real estate world that is the buyer? The answer is going to be D for the word deed. That is the piece of paper that's going to transfer ownership from one owner to the next one, or from the seller to the buyer. The rights is what is referenced to as title. Mortgage agreement, not everyone is going to be getting a mortgage. That's in the financing world. Property appraisal is helpful to know how much the property is worth in terms of market value. Question 2. Which of the following is a mandatory requirement for a deed to be legally valid? A. Witness signatures. B. A legal description of the property. C. Notarization of the deed. D. The guarantee's signature. Question 1 introduced to us what the deed is, which is the document that is transferring the property from one owner to another. Here we're being asked what needs to be on that document to make it valid. If you are debating between B, a legal description of the property, or C, notarization of the deed, or maybe it is D for you, the guarantee's signature. Witness signatures is usually going to be applicable in a will. Notarization of the deed, it is really notarization of the grantor's signature. Yes, it is notarized, but notarization is actually confirming who is signing this document, and that's going to be needed of the grantor, the seller, which makes D not applicable. The grantee's signature is not needed. The correct answer to the question, which of the following is a mandatory requirement for a deed to be legally valid, is the legal description of the property. If you need to review legal description, we have a video that goes into that topic, like lot and block, government survey, or meets and bounds. This is your opportunity to review that topic. We're getting into the next question. An individual wishes to transfer property to a family member without any monetary exchange. Which type of deed is most appropriate? A. General warranty deed. B. Special warranty deed. C. Bargain and sale deed. D. Quitclaim. We're being asked, You want to transfer property to a family member without monetary exchange, meaning there's no money being exchanged. This is a property that you're given because of your love and affection to that family member. Which one is the most appropriate in this case is going to be quitclaim. You will see other questions discussing the other types of deeds. In this case, if you need to review the topic of deeds, this will be a great opportunity to do so. The answer to this question: an individual wishes to transfer property to a family member without any monetary exchange. Which type of deed is most appropriate? It's going to be a quitclaim deed because that doesn't hold the individual transferring the property to any promises. Let's continue. Next question reads, what best describes a marketable title? A title insured against defects. B, a title with a lien. C, a title free from serious defects. D, a title with unresolved disputes. Marketable title. So title is not something tangible in the real estate world. This is going to be the rights that I am getting from the previous owner. And so the word marketable title, from the choices given, it's going to be one that in the future I am able to do something with that property. I can will it to someone when I'm no longer here. I can sell it. I can dispose of it whichever way I want, and there are no issues. No one can come later and say that they own the property. So the answer is C. The question was again, what best describes a marketable title? The answer is a title free from serious defects. We continue on to the next question. A seller wants to guarantee a clear title to the buyer. Which type of deed provides this guarantee? General warranty deed, special warranty deed, bargain and sale deed, or quitclaim? You've seen a question before with these answers. The question again is, the seller wants to guarantee that the buyer is getting a clear title. Which type of deed is going to be applicable to respond to that wish from the seller to the buyer? It will be A, general warranty deed. This one is the one that gives the most protection to the buyer. The seller is bound by 5 promises. So the answer is general warranty deed. The next question, which benefit does a warranty deed provide to the buyer? Is it A, protection against title defects, B, a guarantee of the property's value, C, confirmation of the legal property description, D, assurance of no outstanding liens? The question here is asking us, why is it that I as a buyer would be looking for, or what do I gain from a warranty deed? We're going to potentially, for some, use the strategy of process of elimination. B reads a guarantee of the property's value. That's not what the deed does. Property value is tied to valuation, the appraisal, the market value. And then we have C, we've eliminated that. Confirmation of the legal property description, that's by the method. And so we've eliminated those 2. D as well is reading assurance of no outstanding liens. The stronger answer here is A, protection against all title defects. To review, the question is, which benefit does a warranty deed provide to the buyer? The answer is A, protection against all title defects. We keep going. Next question. At what point does the transfer of title, excuse me for that misspelling there. At what point does the transfer of title in a real estate transaction officially occur? A, recording of the deed. B, approval of the mortgage. C, I repeated myself there, approval of the mortgage. D, signing of the contract. Officially, transfer of title is going to happen when the deed is delivered to the buyer. Here we don't see that option. So it is going to be A, recording of the deed. Keep in mind, not all deed have to be recorded. There's sometimes when I don't want the deed to be recorded. So the true time that legal title transfers to the buyer is when the deed is delivered to and accepted by the buyer. I think we have a couple, maybe 3 questions to go. Next question. What is the distinctive feature of a warranty deed? A, only used in commercial sales. B, transfers no guarantees. C, requires a witness signature. Or is it D, guarantees against all defects? Here the answer is D, guarantees against all defects. The question is, what is a distinctive feature of a warranty deed? And we end up with the answer, guarantees against all defects, based on the answer choices provided. Here's the next question. A buyer is concerned about potential future claims against the property they intend to purchase. Which type of deed provides the most comprehensive protection against such claims? A, quitclaim deed. B, bargain and sale deed, general warranty deed, or special warranty deed. We've seen those answers before, or answer choices. Here, what is the question? I'm a buyer. I'm concerned of any future issues that might come up when I am buying this particular property. So which one, again, provides the most protection to the buyer is C, general warranty deed. How about cloud on title? Here's a question on that. Which scenario best describes a cloud on title? A title transferred with a warranty deed. B, a title with accurate boundary description. C, an unresolved inheritance dispute. A property with no outstanding liens. Cloud is like a cloudy day. It might rain, so there's an issue. Here, the answer is going to be there's an issue. Unresolved inheritance dispute. How about this next question? What is the consequence of an inadequate legal description in a deed? A, invalidation of the deed. B, minor clerical corrections. C, increased insurance premiums. D, delayed property taxes. So we're reading the question again. What is the consequence if the legal description is inadequate? It's not complete. So here we have the answer is the deed could be invalidated. Let's come back to another question about cloud on title. What does cloud on title refer to? Again, here you've seen a question similar. Here the answers are a little bit different. A, an unresolved boundary dispute. B, a lien against the property. C, a pending zone change. D, all the above. So all the above will be the answer to that question. One more, and then we shall review the questions on the PSI exams in terms of how many and the actual content you expected to learn. A buyer seeks the highest level of protection against encumbrances in a property transaction. Which type of deed offers this level of protection? You've seen this before in terms of the answer choices. Is it special warranty deed? Is it general warranty deed, quitclaim deed, or bargain and sale deed? I hope we all got this question correct because we reviewed this multiple times. It is general warranty deed, provides the most protection to the buyer. On the PSI real estate exam, there are 80 questions on the salesperson part of the exam on the national side and 75 questions on the broker exam. 6 questions are on this topic. So yeah, contracts, agency, practice of real estate, valuation, all offer more questions than this topic. But the majority of us, unfortunately, the language here is not really used on a regular basis. So this is one of those topics that we tend to review often. You're going to see questions about types of deeds. You were exposed to that today. You're going to see questions on title insurance and searches, which gets into title insurance policies and title searches. What's the purpose? Potential title problems and resolutions, and then marketable and or insurable title. I'll see you next time.